All right, I'll call this hearing of the Judiciary, Finance, and Civil Law Committee to order. Today is March 7th, 2024. We do have a quorum. The first item on the agenda is approval of the minutes from March 5th. Do I have a motion?
So moved.
Representative Feist moves the minutes of March 5th. Any discussion? All those in favor, please say aye. Aye. Opposed? Motion prevails. The minutes are approved. We will get right to it. I did see Representative Agbaje here. I will move to recommend that House File 3589 be placed on the General Register. Welcome to the committee. Please tell us about your bill.
Thank you, Madam Chair and members of the committee. I'm here to present House File 3589, which seeks to clarify jurisdiction in trust cases. The bill allows for two options for jurisdiction in cases involving trusts. While the law as written should already allow this, there has been recent confusion as to whether the jurisdiction would only apply to actual persons or to the trust itself. In 2023, the Minnesota Court of Appeals decided that the law, as it is currently written, only applied to the actual person and not the trust property for the types of cases listed. Since that was not the intention of the advocates of the law in 2016, we bring this bill now to clarify that jurisdiction in trust cases can apply either to a person or to the trust. Both options would now be available to litigants. And by clarifying this law, it would cut down on unnecessary pleadings and paperwork for clients and extra work for the district courts. So with that, I'll turn it to my testifier who can explain further.
All right. Welcome to the committee. Please introduce yourself and go ahead with your testimony.
Thank you, Madam Chair. My name is John Worrell. I'm a practicing attorney here representing the probate and trust law section of the Minnesota Bar Association. Minnesota trust law gives the courts power to decide many things about trusts. Some examples are whether or not a trustee should be removed, whether or not a trustee's account should be approved, or interpretation of what trust terms mean. In each case, on whatever the issue is before the court, the proceeding can happen in one of two ways under current law. The party bringing the case makes the decision as to which of these two ways they want to invoke the jurisdiction of the court. It is not something that the court decides. The bill clarifies that court cases about trust can be divided in either in rem or in personam jurisdiction. In personam very simply means that notice will be given freely to each party who's involved in the trust. Very similar to a civil lawsuit where a process server or a sheriff has to go out and put a piece of paper in somebody's hands. The way that we have done it for 100 years before the trust code was amended in 2015 and became effective in 2016 is what we call in rem jurisdiction. And this means that notice is done in one of two ways: mailing by first-class mail and publishing in a legal newspaper for 2 weeks. So you can see that in rem jurisdiction is far easier and far less expensive because it does not involve personal service of 10, 20, 30, 40 people that might be involved in a trust. The amendments to the trust code and updating our trust code in 2016 were done to offer an option, an alternative in personam. It was not intended to make the courts describe or decide which piece of jurisdiction should apply to a particular case. And this Court of Appeals case called Swanson, that's exactly what happened. The Court of Appeals in Swanson said, if you want to remove a trustee, you must proceed in personam. And that was simply not the intent of the Bar Association and hundreds of hours of lawyers who practice in this area to put together the updates to the probate, or the trust code rather. So our proposal simply clarifies that in rem jurisdiction that has been the rule of law in Minnesota for more than 100 years remains the same. The 2016 updates to the code simply add a second option that the participants in the trust case, bringing the trust case, can choose, either in rem or in personam. Making this clear will be more efficiently use the court, and more importantly, for those that need to use the court, trust beneficiaries significantly reduce the cost because they will be able to proceed with confidence that in rem jurisdiction will allow them to see their case to conclusion. I'd be happy to answer any questions.
All right. Are there any other members of the public wishing to testify on this bill? right, we'll move on to committee discussion. Representative Niska.
Thank you, Chair Becker-Finn. Thank you, Representative Agbaje. Did I say that right?
Yeah.
Yes. Okay. All right. For your patience, first of all, and coming back and your work on this. Thank you to the State Bar Association section for your work on this. This is an important part of the conversation we have among branches here. Sometimes we say things that aren't completely clear, or sometimes the courts make mistakes, and I don't think it's important that we figure out what happened in the past. And on this particular question, I think it's good that we're working to clarify it. So I appreciate the work that's being done. I was hoping that Mr. Worrell, maybe you could help just everyone to understand a little bit, what are the reasons why it might be necessary to choose one option over the other? Why is it important to have both options? And just in case this is helpful to anyone who didn't go to law school or doesn't know the Latin, in rem means jurisdiction like over a thing, in this case a trust. In personam means jurisdiction over people. I think you explained that pretty well, but just in case that might be helpful, I think, for some people to kind of put that last piece together. But if you could just help us to help people understand why would we want both options? Why would one option be chosen over another?
Mr. Worrell.
Madam Chair, Representative, two answers to the question. The updates that were done to create what is today the Minnesota Trust Code were done primarily to come into conformance with the Uniform Trust Code and the uniform laws. And the uniform laws use in personam jurisdiction primarily. So there was a great deal of discussion as the bill was being drafted as to should we just simply stay with what Minnesota has done for 100 years, or should we add in this option? And the decision came, let's add in the option because it's an option. And so the thinking was, we'll still be able to choose. The answer in terms of when you would use it, what we came up with, and again, discussions 5-6 years ago, was in persona might be appropriate where you have a real private trust or perhaps involving very public figures. Because as we talked about in rem jurisdiction, in order to get court jurisdiction, you have to publish in a legal newspaper. And believe it or not, there are a lot of people that actually read that. And if they see the Dayton Trust is coming up for a trial or some trust action, they may be very interested in that. On the other hand, if all the members of the Dayton Trust want to keep that a bit more under the radar, now again, court proceedings are also public information, but it's not published. So you could literally start that action, and unless somebody picked up the court filing, basically going in personam, serving everybody but not publishing, would allow you to proceed with some level of less publicity. And that's the only thing that we were able to come up with as to an advantage of in personam. Everything else we came up with were basically detriments.
Representative Niska.
Thank you, Chair Becker-Finn. Thank you for that very good explanation. Like I said, this is a good bill. It helps to clarify the statutory language, and hopefully, to the extent there is still any questions as this goes forward, your testimony here will be helpful as well to clarify the history of it. So, thank you again for your work. Thank you, Representative Agbaje, for your work on this as well. And I urge members to vote yes. It's a good bill.
All right. Seeing no further committee discussion, closing comments, Representative Agbaje.
Thank you, Chair Becker-Finn. Thank you to the committee. Appreciate your time and allowing us to come back, and I hope that you'll consider this bill as you put together your package. Thank you.
All right. With that, I will renew my motion to recommend that House File 3589 be placed on the general register. All those in favor, please say aye. Aye. Opposed? Motion prevails. Thank you for coming in. Next up, we're going to do Representative Edelson's bill. I think I saw her in the room. Yep. Okay. So I will move House File 4109 be placed on the general register. Welcome to the committee. Representative Edelson, please tell us about your bill.
Good morning, Chair and members. So we'll have some comedic relief here this morning. So the Competency Attainment Board was established about 2 years ago, and I have with me today the board chair to explain this very small change. We know acronyms matter in a lot of our fields, so I'm going to pass it to Ryan Flynn, if you wouldn't mind, Madam Chair.
All right. Please introduce yourself and go ahead with your testimony.
Thank you, Madam Chair. My name is Ryan Flynn. I am an assistant county attorney with Ramsey County. Many of you may recognize me when we worked on this legislation 2 years ago, as well as some amendments last year. Since then, I have been asked to be chair of the board, and now I'm chair of the State Competency Attainment Board, the board with the unfortunate acronym of SCAB. As a on a personal note, as a card-carrying union member, I am concerned about my secondary email being ryanflynn@scab.org. So we have asked Representative Edelson just to review the name of that and also bring us in line with other state agencies and just be the Minnesota Competency Attainment Board. So instead of being SCAB, we can just be macabre. Thank you.
Maybe MCAB?
To be clear, we have thought of that, and we're planning for our email address to be MNCAB, so MinCob.
Okay,
Yes.
got it. Any members of the public wishing to testify on this bill? All right, committee discussion. It seems pretty obvious. All right, closing comments, Representative Edelson.
Thank you. And I think Ryan Flynn did a great job, so wrap it up.
He did.
Thank
All
you.
right. With that, I will renew my motion to recommend that House Bill 4109 be placed on the general register. All those in favor, please say aye. Aye. Opposed? Motion prevails.
Thank you.
Thank you. All right, moving right along. I'm going to just stay up here because hopefully this won't be difficult. So I will move that House File 4483 be placed on the general register. Members, this is the reviser's bill, annual bill. We do have an amendment, the A24-0221 amendment. I will move that to get it in the shape that the reviser's office and I would like it. All those in favor of the A24-0221 amendment, please say aye. Aye. Opposed? Right. Motion prevails. The amendment is adopted. And going to go right to the deputy reviser to tell us about the bill.
Thank you, Madam Chair. My name is Jeff Case, and I'm here on behalf of the Reviser's Office. This is our annual bill making technical corrections to Minnesota statutes. Thank you for your support, and I'd be happy to answer any questions.
All right. Any members of the public wishing to testify on this bill? All right. Member discussion? Representative Scott.
It's just such an excellent bill. Please support it.
All right. I don't have any closing comments, so I will renew my motion to recommend that House File 4483 as amended be placed on the general register. All those in favor, please say aye. Aye. Opposed? Motion prevails. All right. Thank you to the deputy reviser for having their staff draft these important bills. All right. Next up, Representative Curran. Representative Curran, would you like to move to re-refer House File 4326 to the Public Safety, Finance, and Policy Committee?
Yes, Chair, thank you. That's my motion.
All right, the bill is before us. And then would you also like to move the A1 amendment?
Yes, so moved.
All right. Can you tell us just briefly what the A1 does?
Yep, very briefly, the A1 just adds privacy to the form as part of the mechanism that this bill develops.
Great. Any discussion to the A1? All those in favor, please say aye. Aye. Opposed? Motion prevails. The bill is now in the shape you would like. Representative Curran, please tell us about your bill.
All right. Thank you, Chair and committee members. Today we have the bill before us is important for Minnesota's judges, court staff, and members of their households. They're put at risk by the dissemination and perpetual internet access of home addresses and personal information. So the bill before you, dubbed the Judicial and Court Staff Safety and Privacy Data Act, will help alleviate these concerns. This is a collective effort by the Minnesota Judicial Branch. It's a legislative priority adopted for action this session by the Judicial Council and the Minnesota District Judges Association. The bill does several things, and I think in the interest of time, I'll turn it over to our testifier for details.
All right. Please introduce yourself for the record and then go ahead with your testimony.
Good morning, Chair Becker-Finn and members. My name is Todd Schuffelman. I'm a district court judge serving in the 10th Judicial District. I've been a judge for almost 15 years. I'm currently chambered in Anoka County. Prior to my appointment, I was a prosecutor in Pine County, City of Bloomington, and Sherburne County. I currently reside in Andover, which gives me the honor of being a constituent of Representative Scott. I'm honored to speak to you today on behalf of the Minnesota District Judges Association, whose membership comprises over 300 judges across the state of Minnesota, includes nearly every district court judge and most courts of appeals judges, Supreme Court justices, and senior and retired judges. I'm also representing the entire judicial branch, who through the Judicial Council made the Judicial Court and Safety and Privacy Act a legislative priority. Thank you, Chief Author Curran, who just described the basics of the legislation, which will allow officials to have their personal information classified as private, prohibit its dissemination, and prescribe penalties for publishing a judge's personal information with the intent to threaten, intimidate, harass, or physically injure. My goal today is to share the overwhelming importance of this bill to your judicial branch and to give you a sense of how the concerns and actions around safety are affecting the people who go to work every day to provide the best possible judicial services to all Minnesotans. In January 2024, the Minnesota District Judges Association conducted a survey of our membership addressing safety concerns. You have been provided a summary of those findings, so I won't go through those since you already have those in writing. But we had 239 judges responded. Their answers confirm that Minnesota is not immune from the nationwide outbreak of violence and threats directed at judicial officers. We've seen examples of this most recently. 2 district court judges in other states were murdered in the last couple of years. And Associate Justice Brett Kavanaugh, there's an attempted kidnapping of him not that long ago. So this is a nationwide and unfortunately coming to Minnesota. It's a serious safety concern. Some of the noteworthy comments provided by our members include many judges noted an uptick in threatening behavior towards judges in recent years. Several judges shared threats against their minor children. Pictures of a judge's minor child were posted online. A death threat was made against the judge's children, which noted that they knew where the children went to school, and one judge stated, "Threats to harm my children were particularly concerning. My children's school was only 3 blocks from the courthouse, and they were prevented from walking there simply because of the threats and my job." Many judges noted death threats. The threats have involved very specific forms of torture directed at a judge. A judge's chambers was firebombed. Someone attempted to break into a judge's home and then defecated near it. Another judge shared that someone created a fake video of a bomb exploding outside of the judge's home. Several judges noted that their home address has been compromised and they have or are now considered moving. As you can see, your judicial branch has serious concerns about their safety. We are thankful for the leadership to get this bill in front of the legislature action this year. Thank you. This solution, we recognize, is not without complication. We have been working for months with the stakeholders to try to get this bill in the best form possible for the greatest impact. We have met with Minkoji several times, the Association of Minnesota Counties, the Federal Bar Association, the Federal Bench, taken input from the Data Practices Office of the Minnesota Department of Administration, the Secretary of State's Office, and the State Bar Association. These have been good discussions, and we look forward to these continued discussions as we work to address this very serious issue. And I don't think anybody doubts that it is a serious issue addressing the judiciary in our state. Some have or will raise First Amendment concerns to our bill, and I understand that. But our bill is closely based on the federal Daniel Anderl Judicial Security and Privacy Act, which is named after a murdered son of a federal judge. That was passed with overwhelmingly bipartisan support in December 2022. This law applies to all federal judges in the United States. Many of the arguments you will hear today were addressed as part of the deliberation process of that bill. And in reviewing some of the news reports and the debate at that time, one exception that was in our bill, it was in the federal bill, but it's in our bill, addressed many of that concerns about the First Amendment, specifically the dissemination of personal information if the information is relevant and displayed as part of a news story, commentary, editorial, or other speech on a matter of public concern is not outlawed by our bill. Also, the criminal elements have an intent element as part of it. This goes a long way to answer many of the questions of the constitutionality of our bill. Even the national ACU, while having concerns about the federal bill, did not oppose it. Some have suggested we change our approach to modify something along the lines of the current Safe at Home program. While we recognize and applaud the hard work of the Secretary of State's office to make it a nation leader in covering protected individuals, both with the government and in the private sector, the main goal of that program is considering a comprehensive safety plan, which often involves moving residents, results in all communications through a post office box, and places the entirety of the burden on the participant. Whereas the legislation before you is intended to protect judicial officials and hold accountable those who try to use that means to threaten, harass, use violence against judicial officers through publicly posting, displaying, publishing, selling, and other means to make personal information about judicial officers public. Our goal is to deter that behavior, include an avenue for removal, and provide penalties for non-compliance if directly related to the harming of the judicial official. Thank you very much for your consideration of this important, necessary, and reasonable bill for the safety of the judiciary. Thank you.
Thank you for your testimony. Do you have a couple other people signed up? I have Matt Ealing. All right, and Munira Mohammed. Oh. Please introduce yourself and proceed with your testimony.
Great. Thank you, Madam Chair, Representative Curran, members. Matt Ealing with the Minnesota Coalition on Government Information. Madam Chair, what kind of time restrictions are available today? Is it 2 minutes or?
I believe the committee administrator informed you 2 minutes.
Very good. I'll have 2 minutes for you, and then I can stand for questions.
And I will also note, I believe there's in the handouts, there's information from your organization as well that folks can look at.
Great. Thank you, Madam Chair. As noted, we've submitted some detailed written comments, but I would like to make some high-level points quickly, and I'll stand for any questions. Since October, we have met with representatives of the judicial branch a number of times. The concern they bring to you is serious. We recognize that. We've been trying to find a way to address that concern in a bill that works as well as it can and addresses some of the constitutional and pragmatic issues that we flagged. I'd like to start talking about sections 2 and 3. Section 2 has a prohibition that bars the publication of certain factual information on the internet, and section 3 provides a civil takedown mechanism to remove that factual information. As further detailed in our written comments, the U.S. Supreme Court has struck down these kinds of bars on publication of truthful information in a number of cases that we have cited in our comments. We feel that this kind of content-based regulation created by sections 2 and 3 won't withstand constitutional scrutiny, as regulation of that kind of content-based communication here is not narrowly tailored as the Supreme Court precedent requires, even with the public purpose exception, and I can speak about that in follow-up if needed. So when constitutional matters are involved, you have to ask, as a matter of public policy, can you do something? Not only should you do something, but can you do something? And that directs you maybe to other avenues within policy making. And so we think that because there's going to be constitutional headwinds for this kind of content-based regulation, that sections 2 and 3 should be removed from the bill and work focused on other aspects. So if you look at our alternative language that we've proposed on the back page of our packet, we have kept the criminal provision. We think that's an effective policy mechanism that can address the judge's concerns. We have slightly modified it to make sure that the express intent requirement that's there is tied to other courses of criminal conduct, such as threats of violence. And this separates Section 4 in their bill from Sections 2 and 3 in terms of the constitutionality problems that we flagged.
If you can wrap up.
Oh, sure, certainly. And then Section 1 also has a restatement and clarification of language in the Safe at Home program that we think helps to more explicitly cover government employees like judges. So, Madam Chair and members, thank you for your time. I'm happy to stand for questions.
All right, thank you for your testimony. Next up, I have Munira Mohammed. I'll say for the record is Representative Curran, been in office over a year. It's been said 3 different ways since you got up there, so just for the record, welcome to the committee. Please introduce yourself and go ahead with your testimony.
Thank you, Chair and members. My name is Munir Mohammed, and I'm with the ACLU of Minnesota. We're here to express some concerns on this bill. We agree with the author of the bill that judges and judicial staff should be free from threats and not have sensitive and personal info released to the public. But the language of the bill as it stands is far too broad and could pose constitutional issues. In Section 1, we agree that some data is private and shouldn't be released. The problems, though, arise in the subsequent sections. Section 2 and 3 are far too broad. It covers not only judges, but all judicial employees, and on top of that, any child of any employee in that judicial system. This limitation seems to cover not only daycares, for example, but also high schools, colleges, graduate schools, and beyond. There are numerous ways this information can be shared and publicized appropriately or innocently, yet this bill would prohibit it and even open individuals up to criminal prosecution. The exceptions for matters related to public concern is helpful but potentially confusing in application. It reads like even news stories could still be removed if judicial officials wanted, or criminal penalties imposed if a prosecutor says the speech is intimidating. This would have a chilling effect on First Amendment rights. Section 4 is also problematic. It includes much more than threats. The language would punish the intent of the person publishing the info without having to first prove that a reasonable person would feel threatened or harassed. Without proving the negative effect of the publication, the section is not appropriately tailored to government's interest. For example, what differentiates harassment and intimidation from constitutionally protected rights of protest and petition? Everyone here knows that judges stand for election, and that innately ties citizens to possible community criticism. Free debate is a foundation of our democracy, and we shouldn't fear litigation or criminal punishment. In conclusion, the ACLU supports locking down personal info, and we even support criminal penalties. But the language has to be significantly narrow to address that speech that actually threatens, and there's proof that a reasonable person would perceive it in that way. Thank you.
All right, thank you for your testimony. Let's see. I know there's a couple other people available for questions as we get into discussion. Are there any other members of the public wishing to testify on this bill? Okay. And if there's anyone else other than that person, now is your chance to show yourself, so I don't have to keep asking this question. All right. All right, welcome to the committee. Please introduce yourself and proceed.
Thank you, Chair Becker-Finn. My name is Troy Olson. I represent the Minnesota Association of County Officers, which includes Minnesota County Recorders Association. Just wanted to go on record as saying they have some reservations on how to administer the bill effectively and efficiently, but look forward to continuing to work with those involved to try to figure those out and alleviate those concerns.
All right. Thank you for your testimony. All right, moving on to member discussion. Representative Finke.
Thank you, Chair Becker-Finn. Thank you, Representative Curran, for bringing this bill. Yeah, I just wanted to, I have a couple of comments about this bill because this is a very tricky space. This is one of the spaces that I find to be the most interesting and difficult as a member of this body and as a former ACLU employee and deeply, deeply committed advocate of the First Amendment. You know, I, as a publicly trans person and as an advocate for trans rights, many of the things that were described here are things that happened to me. I have worked very hard to keep my personal information private against what many people consider to be the law. And I think it's really important for people to recognize that these issues are very broad and very serious, and they're just catching up to places who have the power to take action on behalf of protecting them. We should be considering the way that this bill looks. We should be considering why, if these protections are not protections for other members of our government, why not? And if we are going to protect people who are judges, but for example, not all other electeds in all various spaces, why not? But also, what is too far in terms of prosecuting people for speech they may not understand to be harassment? I get what I would consider harassing emails every single day. I know that they are part of the discourse of American First Amendment protected speech, and I just put them in my archive in case I need to come back to them for the record. We have to walk the line super carefully. But I do support this bill because I do think we need to take very seriously the risk of being a part of the work that we do. The work that we do is, and my understanding of what that means has changed dramatically in the last 18 months since I went from ACLU to this job. So I just want to caution us, but also recognize that we do need to take action, and we need to take action to protect the people we value. And judges they have a stature in our world that some other communities just don't have the ability to advocate for. So I appreciate this work. I appreciate the complexity of what Ms. Muhammad and others have brought to the committee. It's really important work.
Thank you. Representative Johnson.
Chair Becker-Finn, Representative Curran, I understand what's going on and why it's looking at doing this. It's unfortunate that our society has got to the point where we can't peaceful protest. It always has to be violent now. How do we fix that? I don't know, but it's really concerning. I know for me, I have a plan in place, and I've worked with my sheriff, if that should happen, to get my family out safely. That's what we all need to do. We have to have a plan in place. And it doesn't matter if you're an elected official, a judge, law enforcement, fire, just somebody who says something. You have to have a plan in place. It's unfortunate that this country is getting so violent. I didn't help when we had, during the protests a couple of years ago, we were seeing buildings burning down and they were calling it peaceful protest. That's not peaceful. Peaceful protest is just standing up there singing or praying is peaceful. Yelling, screaming, and hollering is not peaceful. I believe that the intent of this is good, but I think it's way too broad to the point where it might be actually unworkable. Now, I do have a question. I know there's other states that's done things like this, but we've had issues where law enforcement officers working narcotics, which is undercover, and their address is protected. They can't even, the department can't even say that they work for them while they're on that assignment. Somebody in another state posted their address on the internet, so it became available. They were never in Minnesota, but it was available. How will this affect that if they're not in the state of Minnesota when the crime was committed?
Representative Curran, I think there's a question there.
Yeah, yep, there's a
Okay.
question there. We're just looking at the phone a friend system we have over here.
Yep, go ahead. Yep.
Yep.
Yes, absolutely.
Thank you.
Thank you again. I think I caught about 90% of the question, so I want to make sure I'm answering it correctly. Was your concern about what if somebody outside the state of Minnesota is doing it? What's the jurisdiction in the state of Minnesota? It is a very good question, but we also have the opportunity in other types of crime for somebody's outside of the state. If they're committing a crime in the state of Minnesota, we still have the jurisdiction to prosecute. But you're right, you raise an interesting jurisdiction question. It very well could come up, the reach of our law into another state, but I can let you know, off the top of my head, I'm thinking fraud statutes. Somebody's, you give your credit card information to somebody in Wisconsin, and they run your credit card through, take a lot of your money. They don't get a free pass because they're on the other side of the St. Croix. We still have jurisdiction to do something about. But it's a good question. You're raising some good practical issues that somebody just have to work through. I hope that kind of generally answers your question, Representative.
Representative Johnson.
Chair Becker-Finn, the testifier, it does a little, but with the situation I'm thinking of many years ago, it was decided that nothing could be done because they couldn't prove the intent. They just put the address out there. So it's concerning doing this. I'm just, maybe Representative Curran could explain why we couldn't adjust our current program we have, Safe at Home, amended so if somebody felt threatened, they could get into that program.
Representative Curran.
Thank you, Chair, and thank you, Representative Johnson. I really appreciate this dialogue. I would say that there's a couple different things that happen in the bill, and if I need to get more technical, I might phone a friend on this one too. But there's a couple pieces here, and the one that we're talking about is the distribution of that private data. The second component is if the distribution of that private data is used to threaten someone or is used to threaten and cause bodily harm. And that second component is what we would be looking at for criminal charges. And so with this bill, it's my understanding then that the personal information piece, if simply, somebody posts a judge's address that is meant to be private, this provides that person with the protected information a mechanism to have that information removed legally. So there's no criminal component then to posting that information, so the question of intent there really wouldn't apply. So it would have to be an address with a threat or an address that clearly, has other details along with it that would have implications. But the simple, if somebody took that private address or child's information of a judge and posted it, this would just provide legal action for that judge to have that data removed.
Representative Johnson.
Chair Becker-Finn, Representative Curran. Thank you. I still didn't get the answer of why couldn't the safe at home statutes be amended.
Representative Curran.
Thank you, Chair. And so you're right. This is absolutely not to discourage the Safe at Home program. That is certainly an option that folks still have. But we think that, this gets to a root issue that we're seeing in society. And I know that we had testifiers earlier mention that Supreme Court had struck down a couple of cases. And I know that a couple of those cases happened in 1979, 1989. So the world that we're living in right now with technology and the ability to post these addresses is much, much different than some of the cases that we're talking about that have been struck down. So I think it's just really important that we're addressing an issue that's happening in front of us right now, especially seeing that federal judges had a 50% increase in threats from 300 in 2022 to 457 in 2023. So, this is something that's addressing a very specific, a very recent issue that unfortunately we're seeing happen with technology.
Yeah, and I'll add, a former member of this body to try to intimidate me in a couple of years ago posted my personal cell phone on Facebook and encouraged people to send me threats. And Facebook, there was nothing Facebook could have done, but if you're a judge and that happened, they would be able to point to this statute and Facebook would have had a reason to take it down. Whereas right now there really isn't a lot of recourse for folks. So, and that certainly is a tactic. Doxing did not exist in 1979 as far as I am aware. So it is a different world that we live in. Any follow-up, Representative Johnson? Otherwise, I've got several people on the list.
Chair Becker-Finn, I think I'll let the others continue.
All right. And I will note, too, that Senator Limmer is the chief author over in the Senate. Representative Niska.
Thank you, Chair Becker-Finn, and thank you for bringing this forward. I'm sorry, Judge, that you live in the wrong part of Andover. But no, this is a really serious issue, and it's a very, very difficult issue. And I just want to kind of talk through what I agree with quite strongly in this bill and where my concerns are. And let me add, in addition to just obviously the personal value of judges and their families feeling safe is important, and we as a society should value them. As a system, we also have to value the rule of law and the value to the rule of law that is served by the judges being able to faithfully do their job without fear or favor, and that includes not feeling like they will be harassed or threatened if they do their job in the way that they feel is best upholding the oath and their rule of law. So that is very important, and I think it's important that we as a state value it. I also agreed with almost everything, Representative Finke, that you said, except for I'm not sure that this bill is quite ready yet. And I wanted to expand a little bit on what you said, which is it's more than just the legislative branch, too. There are, like Representative Johnson said, there are law enforcement officials, there are other government officials, there are executive branch officials and employees who we also need to be concerned about. And there's a tricky, difficult line between protest and speech and having a robust public square. There's a very fuzzy line between that and harassing public officials in an effort to coerce them into doing public acts that are, outside of our system of government, where we decide policy issues peacefully, primarily through speech and elections. And the concern I have with this bill is that it's sort of both simultaneously too broad and too narrow, because it's sort of legislating with a little bit of a sledgehammer, but only in one part of it. And so, Representative Curran, I would love for you to help us to think about if we do this to this extent in this area, how should we think at a big picture about, do we take the same approach in all of those other similar areas as well, or how do we distinguish between taking this, again, the best analogy I can think about is we're sort of legislating with a sledgehammer to try to deal with this one particular problem. Are we going to use the same sledgehammer everywhere? And, what are the implications of that, if you have thoughts on that?
Representative Curran.
Thank you, Chair. Thank you, Representative Niska. I agree with you. And I consider this bill to be a starting point. This is addressing an issue that we know is happening in society today. I think if we were to do a deep dive analysis into who faces these types of threats publicly, you're right, everybody you listed faces these types of threats. At the same time, I think doing that work and attempting to build a bill that large would just take too much time to get any traction, and we might never get a good start. And so I think this bill is that good start, addressing an issue that we know exists. I am certainly happy to continue work in this area. As we always do, we're coming back and amending and learning more information and doing better when we know better. So I'm happy to continue that conversation too.
Any follow-up, Representative Niska?
Thank you. I would just say I think that maybe something closer to the Minkoji example is maybe better as the first step in this area. But like I said, your safety, the safety of your kids, the safety of your family, it matters both because of you as people, but it matters to the work that you do for the state of Minnesota. And so I do appreciate you taking on this difficult issue. I don't think this bill is quite there yet, but it's important work, and I appreciate it.
Representative Moeller.
Thank you, Madam Chair, and thank you so much, Representative Curran, for bringing this bill. And I'm glad that Representative Niska just mentioned the Minkoji example, because my questions were specific to that example. And as I read the language, I think that if we were to take out those sections 2 and 3, there just aren't enough protections. If we just have those criminal penalties with the intent, we're going to run into the problem of that information gets disseminated, it's out there, there's no way to take it down, there may not be that intent element with it. Then to your point, Representative Johnson, it might be really hard to prosecute in those other jurisdictions. There may be issues with that, and if we're just left with the criminal language, we are eliminating the ability to take out the harmful piece that's already been done by publishing that information and taking it down. So I certainly understand those concerns that have been raised, but I'm also really cognizant of the fact that if we just do the criminal penalty, it's not going to be enough here. And I was hoping that the judge perhaps could speak to that as well. Thank you.
Judge.
I want to make sure I understand your question or your comment. So you're talking about the dissemination of personal information in subdivision 2 and the exception and taking that out of the bill. Let's make sure I was following correctly.
Yeah, Representative Moeller is good at talking to judges. Representative Moeller.
Thank you, Madam Chair and Your Honor. Section 2 and 3, so the opponents of the bill suggested sections 2 and 3 be removed. I'm really concerned that the bill just wouldn't really have much meat if we were to remove section 2 and 3, and I just wanted to hear your thoughts on that.
All right.
Judge.
Thank you. I appreciate that. 2 and 3 are very important for our bill because that is as I look at it, the first step the person's going to take when they leave my courtroom and they don't like a particular ruling I gave them. Okay, I'm angry. Where does he live? Where can I find it? 2 puts a roadblock there. Not a guaranteed roadblock. Someone looks hard enough, they're going to find me. I understand that. But 2 puts that roadblock there. Hopefully that's enough to stop the person. That's why I think that is necessary. And the exceptions we talked about, those are straight out of that federal bill. And they, right now, as to date, I did some legal research the other night. Can't guarantee that my research was 100%, but I didn't find any challenges to that federal bill. I didn't find any cases indicating that somebody had filed a challenge yet, let alone that it's been held unconstitutional. And as we all know, if there's challenges to a bill, constitutional, otherwise, a lot of times the lawsuit's filed before the governor or the president's ink is even dry on the bill. It hasn't happened. So one thing we need to understand is we're not asking you to necessarily break new ground. It's new ground for Minnesota, but it's based on a federal law that's been there since 2022. And best I can tell, has not been challenged. Doesn't mean there isn't a lawsuit somewhere that I can track down, but best I could see, I didn't see anything.
All right, thank you. Representative Scott.
Thank you, Chair Becker-Finn and Judge Shuffleman. It's great to see you. I think the last time we ran into each other at Target or something, I don't remember, but I agree with what's been said about the high priority of protecting folks that are in our courts. We've seen some all too troubling examples of why a bill like this or those protections are needed. I want to clear the air on a couple of things. Your addresses are already private. They're not public. And that's according to judicial rule. We know that the courts are not subject to Chapter 13, but you do have court rule, and it protects your residential address. So that's not in the public domain now. If somebody wants to find an address, we all know that people can find them, and then and that's where this bill comes in with posting those addresses and so forth. But I'm concerned about the broadness of this. And Representative Curran, do you happen to know if all the people that the courts, we got letters from all these places that are in support of this, all the courts, all the employees, how many people are we talking about?
Representative Curran.
Thank you, Chair and Representative Scott. I think I'll have to, I'll have a testifier come up and answer that for us.
Welcome to the committee. Please introduce yourself and go ahead with your answer.
Good morning, Madam Chair, members. Nancy Haas on behalf of the Minnesota District Judges Association. There are about 2,500 individuals in the judicial branch. I would note that based on input from stakeholders, you will note that a judicial official has to actively fill out a form to take advantage of this bill. And so it doesn't blanketly apply to everyone. They'll have to apply for it. So, but the total breadth of folks would be about 2,500.
All right, thank you. Representative Scott.
Thank you, Madam Chair. So, okay, that's 2,500 people. And does that include their family members, Ms. Haas?
Ms. Haas.
Madam Chair and members, if you look in section 2 of the bill.
Line 2.8.
Thank you. It actually goes through and talks about the Supreme Court, the employees of the judicial branch, and then the name of the child of the judicial official.
So it looks like on line 2.8 and 2.9, it's limited to the judicial official.
Thank you. Yep.
Representative Scott.
Thank you, Madam Chair. Representative Curran, my concern here is it's so far sweeping. And so what mechanism in here is there for when a child that's a juvenile ages out of being a juvenile? So the judge's child is now an adult. Does something happen within all these areas of government that now treats that person differently? Representative Curran?
I think maybe I can answer that one. It does not define a child as a juvenile in the language of the bill. It says a child of, okay, and we're nodding, yep. It's a child of a judicial official, so that would remain, there would be no change in the protection to that child.
Representative Curran, so if an adult child of a judicial official is pulled over for DWI, will that arrest record be made public?
Either one of you.
Madam Chair and Representative Scott, trying to find, we actually have, on lines 2.19 through 2.20, the sentence, personal information may be disseminated pursuant to a specific authorization in law, rule, or with the written consent of the judicial official. That's intended to cover an example, like you're saying, when we're not trying to say that a official that breaks a different law is protected, that sentence right there should cover any other crime or engagement in a crime.
I sense maybe an amendment in public safety where we're sending this next. Representative Scott.
Thank you, Madam Chair. I don't know that that's clear, and it needs to be. Another question would be, so a judge or a family member of the judge that's an adult, they have a business, but they also serve on boards where the business maybe they're making a decision within a business, and it would directly affect the board that they serve on of a private entity. But under this bill, my understanding is that the judge's name or their family member's name would not be made public in those situations. So we would never know if there's a conflict of interest that is occurring. Would that be an accurate statement under this bill?
Ms. Hawes.
Madam Chair and Representative Scott, our intention with this bill is to only cover the actions of the judicial officials and their work as a judicial official. And so to the extent that question remains, we're open to continuing to work on the language.
Representative Scott.
Thank you, Madam Chair. Another concern that I had, and the example was given in the Minkoji paper that they did. So the U12 basketball team, girls basketball team, wins a championship, and the judge has a child on that team, but the coach of that team doesn't understand this law, right? They're not even thinking about that. They're just posting a picture. They're naming the kids, and they put it on social media. Is that coach now guilty under this law?
Representative Curran.
Thank you, Chair. Thank you for the question. And no, that goes back to where there's those two different sections in the bill. So the posting of the data, if the judge, the judicial official had filled out the form to essentially qualify under this bill, they would be able to formally request to have that data removed with no criminal component added to it. If that picture was posted saying something inciting violence against that child or the judge, that's where we would get into intent and that criminal territory. But just, if somebody accidentally posts the information, like you said, then this would just provide a mechanism to have it removed legally.
I would say any coaches listening, don't post kids' names on the internet. That's a bad plan. Representative Scott.
Madam Chair, I'm wondering if Judge Shuffleman could come back to the table. Question for him.
All right, go ahead, Representative.
Thank you, Madam Chair, and thanks, Judge Shuffleman. What's wrong with being part of Safe at Home?
Judge.
Okay. The general answer is there's nothing wrong with the Safe at Home program. For what it's set up for and what it does wonderful work. I see folks who come into court in front of me, many times it's victims of domestic abuse who are trying to do their best to prevent the abuser from tracking them down and finding them. But I've also, in conversations with those people, realized that it's different than what we're talking about here. As I mentioned in my comments, they have more of the general safety plan. I know they don't ask you to move, but that's one of the potentials. You move. All your mail goes to a P.O. box, and eventually it works its way back to you. It's a good program, as I mentioned earlier, but it's just not the tool for what we're talking about here. That's how we look at it through the Judicial Council and through the MDJA. So we appreciate it. We looked at it. We've had some good conversations with the Secretary of State, and I hope in no way does anybody take my comments as any way disparaging that wonderful program. But it's just round hole, square. It just doesn't work for our purposes.
And I can say as someone who's carried Safe at Home bills for years, that really the idea is that the address is what's protected. So you still wouldn't have any mechanism to get like Facebook to take down any of the information outlined in this bill. Safe at Home just kind of helps, like, if you're filing a court order and you don't want that public court order to have your address on it so that, your abuser can find where you live. But it wouldn't do anything about the things we're kind of talking about in a digital social media world. Okay, you're nodding, yes, okay, got it. Representative Scott.
Thank you, Madam Chair. I understand what's trying to be done here, and I support protecting you. I just feel like it's so broad, it encompasses so many people. And, Hennepin County has a bill out there right now that tries to scoop in all the public employees and making all this information private. Right now, their names, their salaries are public, those sorts of things. And pretty soon, the only people that are going to be unprotected are the taxpayers of Minnesota. And I get the world that we live in and all that. I just would love to see more work on this so that it's more narrowly tailored, so it answers more of the questions that I asked, and does a good job at protecting our judges at the same time. So thank you, Madam Chair.
Yeah, thank you. And I will just add, I don't know anything about that bill, and it's not getting a hearing. So people can introduce all kinds of crazy things, and that doesn't mean that they're going to move forward in this body. And, I will just add, because this is an issue that I think is really important, and we have, I think for the record, it's important to note that we've had testimony throughout the years on the difficulties, especially in rural areas, of getting judges to apply to be judges. And, why would anyone want to do this very important, critical work if your kids are now at risk? And I'll just be honest, like, as I was making the decision about whether to run for re-election, I had to put my kids' safety was a factor as I was weighing that. And so we talk about wanting the best folks, making our judicial decisions and running for office. And in the world that we live in, it's not just because of the types of protests that are happening, but it's because of the technology. Back in the day, it was like, okay, so that one guy knows where I live. What is he going to do? Like, put up flyers, I guess. It just doesn't have the reach that the internet does. So thank you for bringing this forward, Representative Curran. It is a very serious issue. I know I'm going to say the thing that I say all the time is that this is why we have committee, so we know what we need to work on. Mm-hmm. So Representative Curran, closing comments before we move this to public safety.
Yeah, I just, thank you, Chair, and I want to thank our judge and testifiers today. And thank you so much, committee, for the discussion. I think we got into a lot of really good details. I am absolutely open to working on amendments as this progresses. I've already had some conversations with other folks prior to today where, we're already looking at some changes too. So this is a new idea, and so we want to make sure that we get it in the best shape we can before it passes this year. And then, like I said before, I'm happy to continue work to tweak things in the future if we need to.
Thank you. That was closing comments, Representative Scott. I'll allow it, yeah.
Madam Chair, in regard, it's going to public safety. If it's amended there,
No,
can we get it back?
probably not. We've got 2 weeks of committee left. I'm sure that Representative Curran is open to having conversations with folks, but that's not a thing I've typically done just because it isn't. Nothing would pass if I had to call everything back to this committee. I think this has been a thorough discussion of the concerns and thoughts of this committee, and it would not be in my intent to call this bill back to this committee since we've had a really thorough discussion with public testimony here. So thank you. With that, Representative Curran renews their motion that House File 4326 as amended be referred to public safety. All those in favor, please say aye. Aye. Opposed? Motion prevails. Thank you, Representative Curran. Representative Huot. I will move to re-refer House File 2509 to the Health, Finance, and Policy Committee. Representative Huot, please tell us about your bill.
Thank you, Madam Chair, and thank you, members, for hearing the bill. It's a pretty straight, simple, forward bill for workforce. Pretty much more focusing on greater Minnesota because of our shortage of morticians. This bill basically opens up a new level of who can actually remove a decedent from a place of death. The reason it's in your committee, it's Section 10 and Section 11. I have with me today Joe Selwood of the Minnesota Funeral Directors Association that worked on this bill and can kind of go into the details of it.
All right, staff, don't crosstalk while I'm trying to run committee, guys. Sorry, Representative Huot. Please introduce yourself and go ahead with your testimony.
Thank you, Madam Chair. My name is Joe Selwood, and I'm testifying on behalf of the Minnesota Funeral Directors Association in support of House File 2509. Currently, only licensed funeral directors, only licensed morticians, are permitted to remove a dead human body from the place of death. Workforce shortages have caused challenges for morticians to make these timely removals, and families should not have to wait multiple hours for the removal to occur. This proposal seeks to be a solution. House File 2509 creates the transfer care specialist and authorizes this individual to make removals and transport to a licensed funeral establishment, given that they have training, pay a fee, and register with the Department of Health, and are supervised by a licensed mortician. As Representative Huot said, the reason for being here today is the addition of transfer care specialists throughout 149A in order to align with references to morticians and interns, and specifically the additions in Sections 10 and 11. Section 10 of the bill adds transfer care specialists to the existing law requiring courts to report certain judgments and determinations on licensees to the Department of Health. This court reporting provision is standard across regulated health professions where there's patient interaction, and it's included in the mortuary science section because of the interaction with decedents. The courts have noted there's no cost to adding the transfer care specialist to the reporting requirement in Section 10. Similarly, transfer care specialist is added to Section 11, which provides immunity from civil liability and criminal prosecution in the event of a self-reported violation. House File 2509 will provide an option for funeral directors to facilitate more timely removals through the use of transfer care specialists. MFDA thanks Representative Huot and the committee for their consideration. Thank you, and I'm happy to answer any questions.
All right, are there any other members of the public wishing to testify on this bill? All right, not seeing any, we'll move on to member discussion. Representative Scott.
Thank you, Madam Chair. I'm sorry, I missed the motion. Where's this going next?
Health, Finance, and Policy.
Okay. Thank you, Madam Chair. And so if there is a fiscal note, because there's quite a fee here, And I understand that stakeholders might be working on that fee and bringing that down a little bit. I don't know if Representative Hewitt wants to.
To my knowledge, it wouldn't be any, the costs are not expected to be within the jurisdiction of this committee. That's why it's going back to health, because I think MDH is where the cost would likely occur. And Mr. Selwood is nodding his head. Anything further, Representative Hewitt, on that?
No, it's exactly right. There's current negotiations going on with that fiscal note, and MDH is here, but it does fit in the health fee, and we're being worked out. Thank you for that. That's a great question, though, Representative Scott.
Yeah, primarily this bill came to us because of the immunity section and making sure we had the ability to vet that.
Right. Thank you. Thank you, Madam Chair. I don't have any other questions. That was just a concern I had.
All right. Closing comments, Representative Hewitt.
Great bill. Help us with the workforce.
All right. With that, I will renew my motion to refer House File 2509 to the Health, Finance, and Policy Committee. All those in favor, please say aye. Aye. Opposed? All right. Thank you very much. I know I saw Chair Lee was here. Yep. I will move to refer House File 671 to the Environment and Natural Resources Finance and Policy Committee. Welcome to the committee. Representative Lee, please tell us about your bill.
Thank you, Chair and members. So I'm bringing this forward because over the last few years we have had a few high-profile, polluters in our communities, and I think over the years, my neighbors in my community are asking why are these bad actors able to continue to operate in our community without, facing any consequences. And so as I look more into this issue, I saw that. One, we have very low penalties for polluters, and two, not really have anything on the books for repeat violations in terms of civil penalties. And so, looking at section one, looking at the civil penalties in amount of section 115.071 subdivision 3 as it relates to water, air, and land pollution, they were first established in 1973, and then for hazardous waste in 1983, and these have not been updated since then. And then looking at the administrative penalty in section 116.072 subdivision 2, which was first enacted in 1987 and then amended in 2014. I thought that I think that it is time for us to consider really increasing them, and so the bill increased the civil penalties for any person who violates any provision of Chapter 115, 114C, or 116 from $10,000 to $70,000, and for any that's relating to hazardous waste to $80,000. And these fees amount, we're just looking at adjusting it to inflation from when they were first set in 1973. Additionally, I added a provision to increase the penalty of repeat offenders to at least 10% higher of the penalty amount assessed for a violation within the previous 36 months. The bill also increases the administrative penalty the commissioner or MPCA or county board may issue from $20,000 to $25,000 for violations. Like I mentioned before, this was first enacted in 2010 and increased in 2014, and so adjusting for inflation from 2014 to 2024, that's approximately $25,000. And then the bill requires that for a repeat or a serious violation, the commissioner or county board must issue an order with a penalty that will not be forgiven, and a penalty for a repeat violation that occurs within 36 months of one or more previous violation must be at least 10% higher than the penalty imposed for the most recent violation. This section relates to a finding from the Office of the Legislative Auditor's report on water gremlin polluter that's in the chair's former district and now in Representative Curran's district. And I would just read, just that little snippet that the OLA found, they said, and I quote, "We think it is reasonable that the MPCA has latitude to make judgments about how to best to bring a company into compliance. In this case, the MPCA thought that a 2001 schedule of compliance could get Water Gremlin to comply with its permit going forward. But looking back, it is worth noting that Water Gremlin started its long history of permit noncompliance as soon as its initial 2000 air quality permit was issued, and it received no financial penalties for noncompliance until the 2019 stipulation agreement. If MPCA had issued penalties for permit violations based on publicly available data for 2000 to 2002, perhaps this would have been sent a stronger message to Water Gremlin, possibly affecting the company's compliance in subsequent years. And so, what I'm proposing today, I think that, communities like mine and those that has been impacted would like to see, that bad actors actually face some consequences financially so that they will stop with their actions. And so with that, Chair and members, I'm open for questions, and I think the NPCA is here. I don't know if they're going to testify or not, but they're here.
Yeah, we got Tom Johnson signed up. Please introduce yourself and proceed with your testimony.
Thank you, Madam Chair. And for the record, my name is Tom Johnson, Director of Government Affairs at the Minnesota Pollution Control Agency. Thanks for the opportunity to testify today on House File 671. I want to be clear, the agency does not oppose House File 671. In fact, we think it's important to look at these enforcement statutes from time to time. The agency has its own update that we're proposing this year to our enforcement statutes, so I think it's important that we revisit these from time to time. There are some areas where we would appreciate some clarity, or some areas where I want to flag for the committee where there could be some consequences or how these might play out. So just really quickly moving through the bill, and I do appreciate Representative Lee has already taken into account several items from the agency, and so just continue to appreciate that collaborative work, and we're happy to continue to work with him on the bill. When we look at 1.14 and 1.17, of course, the committee will see those increases to the penalty caps. Of course, this committee, members of this committee will understand that this is really, it will be the court that decides what the final fine would be. This would not necessarily mean that fines would, or that penalties would increase in those cases. It is pretty rare currently to see a judge meet the 10,000 per day cap as it is. And so, just flagging for the committee that ultimately there could be a change or there could not be a change depending on what the judge would decide or the court would decide in that case. Under 1.18, paragraph B, to clarify, the agency does already consider repeat violations when we are bringing forth a case. There are usually those repeated violations are within the same type of violation, is what we would consider. The way that this is phrased, we could see a situation where there might be a little incongruity, where there's a serious violation brought forward, results in a major penalty, and then subsequent violation of a different sort might be a very small violation, like submitting a document that the agency requires late. That might be a violation technically and would then require a fine that is higher, 10% higher per day than the original violation. So just pointing that out as a potential consequence.
And I'm going to have to ask you to wrap up. We do have one more bill we have to get to today.
Thank you, Madam Chair. So moving to subdivision, or section 2, subdivision 2, want to thank Chair Lee for this. Again, these APO penalty order amounts, it would be appropriate to update these. They haven't been updated in 10 years. The EPA, our federal partners, tend to update their penalties very often to adjust for inflation, and that hasn't been done in 10 years here in Minnesota. Really quickly, 3.3, this effective date. Want to flag that an immediate effective date would affect current enforcement cases that are open. So we just want to clarify that that might have some consequences. We might have to revisit some of those currently open enforcement cases.
Yep, and I'll just remind you, we are sending this back to Environment,
Yep.
so there's plenty of time to work with Chair Lee on
Absolutely.
Anything that might need to be cleared up.
Yep. Thank you, Madam Chair. I'm happy to stand for questions.
Any other members of the public wishing to testify on this bill? All right, not seeing any, we'll move to member discussion. Representative Johnson.
Chair Becker-Finn, Representative Lee, can you explain why we have to increase the penalties so much from $10,000 to $70,000 cap? $25,000 to a $80,000 cap per day?
Chair Lee.
Thank you, Chair and Representative Johnson, for the question. Like I mentioned before, this is adjusting to inflation. And if, hopefully this will help us, put this into perspective. With the current, number being the way it is, if we were adjusting it back to 1973 standard, the penalty right now will be an amount of $1,000. And so I think that this is not being drastic. We're just moving with time. And so that's why it's increasing from 10 to 70, and then from the other one to the 80,000.
Representative Johnson.
Chair Becker-Finn, Representative from the, thank you for the answer, but it was interesting earlier in prior sessions when they were raising this fee it was to get people to follow the law. So this, at least you are honestly trying to do it with inflation, but I think still that is a little outrageous. Most businesses, $70,000 a day, they'd be out of business in a week. And those people would be unemployed. And I want to thank MPCA for the work they do, working to find it, working with the companies, trying to fix the issue. Sometimes it's something happens where it's not the company's fault and they're getting these fines. But the other issue I have is where they can't adjust it or negotiate, because that gives MPCA an opportunity to work with the company to fix it. I think you need to look at that, because I think it's important to give them the flexibility to make sure they work with the business so things get cleaned up and things don't happen again. Thank you.
Any comment, Chair Lee?
Chair, I really appreciate that. And I think, when we think about this, we should think about the people that are impacted in our communities. So think about those community members in North Minneapolis that has been impacted by these heavy industry, and they're continuing to operate there. And so what is the cost to them? With their health care, we have some of the highest, health disparities in the state of Minnesota. And then, what I just cited with Water Gremlin, that's in the chair's district and Representative Curran's district, where we have given this flexibility. And, Ole actually said that. We don't know if they would have fixed it, but we don't know right now because they didn't have any financial penalties until 2019, since 2000 to 2019. And I see that we already have cases in front of us that's not working, and so that's why maybe we should try something different.
All right. Representative Niska.
Thank you, Madam Chair, and Representative Lee. I did have a comment or a question about the removing the flexibility for an enforcing agency, either the commissioner or the county board, to seek a forgivable penalty. I'm concerned that this actually might have the opposite effect in certain circumstances, where an enforcement agency might feel like they can't fully come down on a offender if they don't think an unforgivable penalty is appropriate, and they might end up having to pull back, or thinking that it's actually makes more sense in the circumstance to pull back and not penalize something that they otherwise would penalize as a repeated or serious violation. And so I think that needs to be played, we should let experts in a particular case, I think, look at the best situation for that particular case. I understand there are certain circumstances where we think they should, maybe should have gone after an unforgivable penalty. But as a legislature, I'm concerned about sort of imposing that on them at the front end and putting them in a difficult spot where they might end up actually having to pull back in a situation where we would want them to find some sort of more of a middle ground. So if you want to comment on that or something, but that would be a feedback from my perspective, maybe to think about in that provision.
Chair Lee, briefly, because you got one more bill we got to get to.
I don't really have much, Madam Chair. I already mentioned that already, that, we already see, with the current flexibility, that this is sometimes not helpful. And so, I think this is a different approach.
Representative Finke.
Thank you, Chair Becker-Finn. Thank you, Chair Lee, for bringing this. We heard this in environment. I just want to make sure that we understand what we're talking about. I think these fees are far too little. I think certain circumstances meet what we're talking about. When you say certain circumstances, is entire communities being poisoned. People are dead because of this. Entire schools outrageously high cancer and their students are dying. The idea that we would allow flexibility to 19 years to poison entire communities, this is what we're talking about. This is unbelievable to me that we are allowing the people to poison communities. With all due respect to MPCA, there is no enforcement of these permits to pollute. We have allowed them to pollute because we have hoped that they would do the right thing. We know they will not, and we have to make it sting. Thank you.
All right, closing comments, Chair Lee.
Thank you, Chair. And like I said, this bill is going to go back to Environment Finance, and I look forward to continuing to work with the MPCA and other members who are interested in this.
All right, I will renew my motion to refer House File 671 to the Environment and Natural Resources Finance and Policy Committee. All those in favor, please say aye. Aye. Opposed?
No.
Motion prevails.
Thank you.
All right, Representative Hansen. This is my first biennium not on the Environment Committee. I get to hang out with you guys again. I will move to refer House File 3874 to the Environment and Natural Resources Finance and Policy Committee. Representative Hansen, please tell us about your bill.
Thank you, Madam Chair and members. I'll be short because I know the time is short. The first section on administrative penalty orders sets that requirement the same as the Wetland Conservation Act. So it's the same level, makes the buffer law same as the Wetland Conservation Act. That provides for stepped, it's an up to, there's stepped enforcement, and Representative Johnson, if you look at the bill, it also has a provision for waiving the penalty if they come into compliance. Secondly, the data practices provision is the same provisions as the Ag Water Quality Certification Program. So there are 23,000 Minnesotans who've signed up for lawns to legumes. They are in every one of our districts. What this does is says that they're not going to get advertising mailings. They're not going to get political mailings. That list would not be available. It makes that list non-public. So I'd ask for your support.
All right. Don't have any testifiers signed up ahead of time. Are there any members of the public wishing to testify on this bill? Not seeing any. Representative Scott, I understand you have an amendment.
Yes, I do, Chair Becker-Finn. And do you want me to speak to that then?
Please go ahead. Why don't you
right.
move your amendment if that's your intent, and then go ahead and tell us about it.
Yes, I will move the A1 amendment to House File 3874. Representative Hansen, while I appreciate your comments addressing making the data private, I don't think that's a good enough answer. If all these people are getting these services, and my understanding is that they're free, the government's paying for the Lawns to Legumes program, and it was greatly expanded last session, if I remember correctly. The public has a right to be able to drive by these places and see what their money is being spent on. We can't start exempting folks that are getting grants and government dollars. We can't start, just giving carve-outs for them as far as making this information public. So I would ask for member support.
All right. To the A1 amendment, Representative Hansen.
Madam Chair, members, I would oppose the A1 amendment. As I mentioned before, this protection for data is provided to the Ag Water Quality Certification Program so that farmers don't have somebody driving by to look at what their implementation is. So it's the same thing. We're trying to provide that. Protects the data, not going to be used for advertising, not going to be used for any other purposes, and I think that is a good thing.
All right. All those in favor of the A1 amendment, please say aye.
Aye.
Opposed? No.
No.
The motion does not prevail. You guys got sleepy this late in committee.
More coffee, madam.
All right. Seeing no further discussion, well, I guess discussion to the underlying bill. I mean, I think you kind of made your point, Representative Scott. All right. Closing comments, Representative Hansen.
It's a good bill. Ask for your support.
All right. All those in favor, I will renew my motion that to refer House File 3874 to the Environment and Natural Resources Finance and Policy Committee. All those in favor, please say aye. Aye. Opposed?
No.
Good job, guys. Motion prevails. All right. Thank you, members. I think we had a really good discussion today, and we will see you next week. With that, we are adjourned.